Welcome to the Know Your Rights presentation on digital security and ICE encounters, hosted by the Rutgers Center for Security, Race and Rights and Muslim Advocates. Our featured speaker today is Golnaz Fakhimi. Before I introduce her, let me tell you a little bit more about the Center for Security, Race and Rights, which is the first and only center at a U.S. law school focused on the civil and human rights of Muslim, Arab, and South Asian communities. The work of CSRR has never been more essential because our country is currently facing significant structural threats to the rule of law, to free speech, to academic freedom, and to our individual liberties by right-wing special interest groups and right-wing politicians that go all the way up until the White House, who have no regard for our civil liberties and civil rights enshrined in the US Constitution. So through a cross-racial and interfaith and interdisciplinary approach, CSRR works on issues that most impact the communities that are also the most directly targeted by the current ICE mass immigration, or excuse me, mass deportation and mass kidnappings that we've seen across the country. The first targets have been Palestinian students, especially international students. They've also been Palestinian American students, Muslim American students, South Asian American students, Black students, and even Jewish students have also been targeted by the police, in some cases by ICE, and in other cases by the FBI, with recent searches and raids of student activists' homes. This Know Your Rights is geared to training, to educate and train students on the current threat landscape and to teach students how to understand their rights and the different degrees of vulnerability, encourage and instruct on digital hygiene and security, and how to approach confrontations with ICE. So without further ado, I would like to now introduce our guest speaker, our expert, Golnaz Fakhimi, who serves as the legal director of Muslim Advocates. She has worked with and for historically and structurally marginalized people across a wide spectrum of contexts and strategies. Golnaz Fakhimi's experience and expertise encompasses deportation defense, criminal defense, and defense of alleged war on terror suspects, habeas corpus actions, civil rights actions, and technical assistance to movement lawyers and partners. Most recently, Golnaz was a senior staff attorney at the Civil Rights Education and Enforcement Center, leading its work at the intersection of immigrant justice and disability justice. And she previously taught the Immigrant and Non-Citizen Rights Clinic at the CUNY School of Law and held positions as an immigrant rights attorney at the ACLU of Pennsylvania, a staff attorney at Appellate Advocates, an immigration staff attorney with the Bronx Defenders, and a staff attorney with the International Justice Network, representing clients at trial and appellate levels across a variety of administrative and judicial fora, training the next generation of advocates, and educating the public through trainings and media advocacy like she will today. Golnaz roots her practice in community-led movements for change. So I can't think of a better and more qualified person to provide this essential and timely Know Your Rights workshop on digital security and ICE encounters. And so with that, Golnaz Fakhimi, thank you so much for joining us and lending us your expertise. The virtual floor is yours.
Thanks so much, everybody. I hope you can hear me okay. I'm going to share my screen. Bear with me while I do that. And I'm going to work off of a PowerPoint. I just need to do this. So I've titled my remarks and presentation Viewpoint-Based Targeting of Non-Citizen Speech, although we're going to get into some related issues as well. In terms of a roadmap for what we're going to be covering together, we're going to kick things off by going into the context of the current political climate and the threat landscape. What are the foundations for the ideological targeting of non-citizens that we're seeing unfold around us? Number two, how we can understand together sources of threats and assess related immigration risks with each other. Number three, how we can know our power, how we can consider ways of reducing risks to ourselves. And then finally, what are ways that we can plug in and resist the sort of repressive climate that faces non-citizens and citizens alike? So in terms of understanding the current threat landscape, I think that foundationally there are a few executive orders that kind of set the stage for viewpoint-driven targeting of non-citizens. One of those executive orders issued on Inauguration Day. It's a bit of a mouthful, the title, but it's called Protecting the United States from Foreign Terrorists and Other National Security and Public Safety Threats. In advocacy circles, many of us refer to that executive order as a vetting and bans related executive order because that's mainly what it focuses on and what it does. It's pretty extensive in terms of its scope and its contents. But I think for purposes of my remarks, I want to kind of zero in on the aspects of it that tee up ideological targeting of non-citizens. So there's content in this executive order that very much sets the stage for immigration-related scrutiny, targeting, and consequences at the border, within the interior, and in the context of applying for affirmative immigration benefits. Based on conduct of non-citizens that in the administration's view calls for quote unquote sectarian violence, whatever the administration might understand that to mean. Or even more broadly, it allows for this kind of targeting of non-citizen conduct that in the administration's view calls for quote unquote the overthrow of the culture on which our constitutional republic stands. And I think it's really worth pausing with each other on the use of a word like culture within an executive order like this, because I think we all know what a sort of malleable term that is. And I think we also all have a sense of how the administration itself might be understanding culture and what fits within it and what doesn't. There's been a lot of rhetoric both on the campaign trail and certainly since power changed hands, to suggest that this administration reads culture through a lens of white supremacism and Christian nationalism. And I think what that means is this language in the executive order sets the stage potentially for ideological targeting, viewpoint-driven targeting that could put within its crosshairs virtually any viewpoint to which this administration is opposed. And so I think this aspect of this executive order is very much part of the foundation of this sort of climate of viewpoint-driven targeting of non-citizen speech. There's another executive order that very much fits into this as well. It's titled Additional Measures to Combat Anti-Semitism. And I think within advocacy circles, a lot of us refer to it as an anti-Palestine executive order because in essence, its terms amount to that. It's worth pointing out that this executive order isn't, its impacts are not limited to the interests of non-citizens. This executive order impacts everybody within the United States. And so I'll unpack briefly kind of what this executive order does. I think chiefly it adopts a definition, of anti-Semitism, that allows for the conflation of anti-Jewish hate with criticisms of the Israeli government or support for Palestinian lives and freedom. So, everything else that this executive order does, I think implicates those viewpoints as a result because of this flawed definition of anti-Semitism that sweeps into it a lot of protected speech under the First Amendment that is core political speech. So the executive order does a variety of things. I think for our purposes, I'm going to focus our attention on the content within it that's very laser focused on international students. So there's a part of this executive order that basically directs federal agency heads to provide the president with recommendations for guidance that the administration could disseminate at scale to campuses of higher education, so that campuses in turn can quote unquote monitor international student conduct, to see if it maps onto any terrorism related grounds of immigration detention and removal. And so I think, the kind of witch hunting that this part of this executive order sets up is deeply alarming, especially the role that it envisions for campuses to be sort of complicit and to capitulate in this project of targeting international students who've been visibly critical either of the Israeli government or the US government in its support of the Israeli government, or otherwise supportive of Palestinian lives and freedom. So these two executive orders really set the stage, but the foundation isn't limited to the executive orders themselves. We've also seen quite a lot of very hardy rhetoric that's been voiced with a lot of gusto from the very highest levels of the government, including at the level of the president, the level of the Secretary of State, really full-throatedly and unabashedly embracing their project, their prerogative of seeking the deportation of international students who have protested over the past year and a half, in which there's been an ongoing genocide against Palestinians in Gaza. And then I think beyond the rhetoric, all of us know all too well that there's been action that's made good on that rhetoric. We've seen now a growing list of international students, starting with Mahmoud Khalil and most recently including Mohsen Mahdawi, who, for all intents and purposes, seem to be expressly targeted because of their visible viewpoints on Palestine, and possibly because of Palestinian heritage in at least some instances. So this is a hugely concerning pattern that I think rightly has grabbed headlines, and it's involved, the abduction of students off our streets, where they've been secreted to remote detention facilities, for the purpose of separating them from families, from communities, from the reach of courts where their claims may stand a chance, and from legal resources and attorneys as well. I think it's worth zooming out to kind of underscore what is an engine for this kind of targeting. In essence, it's widespread dragnet social media surveillance and digital surveillance that we think is a primary driver of this kind of targeting. This isn't anything so new or limited to the current administration, to be clear. Dragnet social media surveillance is something that has spanned a number of administrations going back pretty far in time to the immediate aftermath of the post 9/11 climate. And different federal agencies have very powerful tools that they use to undertake this dragnet surveillance of public source information through social media and that's otherwise online. And I think we'll talk more about what that means in terms of risk assessment and sort of weighing whether and how to consider changes to behavior and decision making. I think we've seen how the targeting that's viewpoint driven seems very much to be predominantly focused on viewpoints critical of the Israeli government or supportive of Palestinian lives. And I think these viewpoints are very much at the tip of the spear of ideological targeting of non-citizens. But I do want to stress that I don't think that that targeting has been limited to those viewpoints. There are at least some data points to reflect that other forms of non-citizen activism have been targeted as well. So I'm speaking to you from Colorado, and there's an immigrants' rights activist here named Jeanette Vizguera, who seems to have been targeted for her activism. Likewise, there's another immigrants' rights activist in Washington state named Lelo Juarez, who seems to have been targeted for his activism. And then there's been news coverage to suggest that, a French researcher, presumably a white man, had been denied entry into the US, at least in part because of having content on his phone that was critical of the president. So, I think that this is all important food for thought, but I think the tip of the spear very much is Palestine advocacy. Lastly, I want to kind of flag here that ideological targeting is invariably going to intersect with other forms of governmental targeting against our communities, including targeting that's based on national origin discrimination, religious discrimination, discrimination on the basis of race or ethnicity, and discrimination on the basis of gender identity. I think this administration has been very vocal in how oppositional it is to uh, non-heteronormative frameworks and understandings of gender, among other things. Um, in terms of how do we kind of ask ourselves what the threat landscape means for any of us, I think a good place to start is thinking about what are the sources of risk. And by this, we mean what are the government entities that pose risks, meaning what are the government entities that have authority to pursue immigration consequences? And what kind of information about our viewpoints do they have access to? Number two, in terms of assessing risks, what are the vectors of exposure for possible viewpoint-driven immigration-related risks? Meaning, what are the ways that the federal government can know about us and our viewpoints, and sort of mapping that out? And then finally, there's weighing risks. So what are personal considerations that might be important to consider in assessing how to understand and weigh risks for yourself? And I think it's important to sort of name here that in providing guidance that's public facing or in individualized confidential consults, the goal is never to say, do this, don't do that. That's never the goal. The goal is always to provide information so that people can make informed decisions for themselves about how to weigh risks against other values and sort of prerogatives, including for many of us, the prerogative to remain vocal and expressive, including in visible ways, about viewpoints that mean a lot to us. When we talk about sources of risk, we're really talking about governmental entities that have authority to undertake adverse actions against us with respect to immigration scrutiny and consequences. So on the left hand of the slide, we've delineated some sub-agencies that fall under the umbrella of the U.S. Department of Homeland Security. U.S. Department of Homeland Security, it is sort of a creature of the post 9/11 climate. And I think for our purposes, it's worth flagging to you three sub-agencies, and I'll actually tack on a fourth. So one is Customs and Border Protection, or CBP. It has authority to enforce our borders. Number two, there's U.S. Immigration and Customs Enforcement, or ICE. It has the authority to enforce the immigration laws within the interior, and very specifically, that means it has the authority to charge people removable and to put them in immigration detention and start removal proceedings against them. Finally, there's U.S. Citizenship and Immigration Services, or USCIS. It is not technically a law enforcement agency in contrast to ICE and CBP. Its job is to process applications for affirmative immigration benefits, things like green cards, work permits, adjustments of status, things like that. But it's worth knowing that anytime someone engages with that agency as an applicant, there's at least the possibility that USCIS and its review and adjudication of applications may refer given individuals to U.S. Immigrations and Customs Enforcement or flag them within a CBP database. So there is that nexus, and it's important to kind of flag it. A fourth agency that's not on the slide, but that I think is important to name to you all, is the Transportation Security Administration, or TSA. I hope I've gotten the acronym right, but I think all of us are familiar with TSA in that it is in charge of security at airports within the interior, even for domestic travel. And I bring them up to say that as a sibling agency under the umbrella of the US Department of Homeland Security, I think it's going to be important for all of us to stay open-eyed about the extent to which information sharing may be happening between it and its siblings under the DHS umbrella, because that may have relevance for those of us who are more vulnerable in terms of immigration status and immigration risk. On the right-hand side of the slide is a separate agency, the U.S. Department of State. It is in charge of U.S. foreign policy. Its components include U.S. embassies and consulates all over the world and other countries. And one of the things that it does through those embassies and consulates is it issues visas, meaning entry permits. And entry permits, visas are what allow non-US citizens to gain entry into the US for a given purpose and a given duration. And I think international student status, F1 status, is certainly one example. It's really important to flag to you all that there's a difference between the entry permit, the thing that you present to CBP to demonstrate that you're authorized to come in for a given purpose and a given duration. There's a distinction between that entry permit and the legal status that you attain as some sort of a visa holder once you've gained entry. Those two things are different from each other. And in the current threat landscape, there are independent threats actually that relate to each of these things and that can be sources of exposure for risk of immigration enforcement. And we'll talk a little bit more about that later. So in terms of assessing risks, for all of you, I think we want to kind of uplift the following kinds of factors. So the particular immigration that someone within immigration status that someone within the interior has says something about the nature of their exposure to immigration enforcement and the kinds of procedural rights that they may be entitled to within the interior or at the border or both. So, you know, there are lawful permanent residents, there are non-immigrant visa holders, there are folks who have fallen out of status, and then there are undocumented folks. And I think that folks who are out of status and undocumented are more vulnerable in some ways to at least certain kinds of immigration enforcement. Although in the current climate, I think we're seeing how viewpoint-driven targeting is taking aim at lawful permanent residents and sort of upending certain kinds of assumptions that may have applied before now in terms of relative risk spanning different kinds of immigration status. Another factor that's relevant to risk assessment is nationality and racial identity. And I think it's just worth uplifting that, people who come from Muslim majority countries, non-citizens who are Black, may face higher risk of certain kinds of immigration enforcement because of their national origin and ways in which related national origin discrimination misattributes danger to people based solely on national origin. And this is very much, I think, something that is an ongoing legacy of the post 9/11 climate, certainly, but it's something that precedes the 9/11 context as well. And sort of, I think there's a lot to say about why that is, but it's a racialized, biased read of danger that misattributes to non-white people or non-Christian people danger. Another factor that's super important to zero in on in thinking about risk is, any history of any prior immigration-related scrutiny. So what do we mean by that? Like, for non-citizens who've crossed the border before, the question would be, have you ever faced heightened scrutiny in any of your reentries into the US? Have you ever had contact with ICE before within the interior? Have you sort of been through an immigration removal case before? These are things that I think are relevant to risk for understandable reasons. There's also contacts with the criminal legal system. So, some of you may be familiar with the extent to which the criminal legal system and the immigration and border enforcement systems are interlinked, certainly with respect to information sharing. And I think that anyone who's had sort of contact with the criminal legal system, because of sort of showing up in a related database, and the way that federal, state, and local information sharing happens, it may mean that you're more visible to immigration enforcement and border enforcement authorities as a result. And then last but not least, a really important, I think, aspect of risk assessment in this climate is the extent and visibility of viewpoints on Palestine or to which the administration is otherwise hostile. So when we're talking about viewpoint-related exposures, I think the delineation on this slide is a useful rubric to kind of guide us through a way of answering one of the questions I flagged earlier, which is, what are the different ways that any relevant federal governmental agencies might know about us and our viewpoints, especially viewpoints to which the administration may be hostile? So I think starting with social media, I flagged to you that dragnet social media surveillance has been a prevalent practice of federal agency sort of law enforcement prerogatives for quite a long time. And I think that under the current administration, it's ramping up in a lot of ways. So I think in reference materials that we'll be providing you after the webinar, you'll see some links to indicia of this. But basically, every relevant agency is leaning hard into social media surveillance. And so for any of us as end users, I think the following considerations are relevant. What are the settings that we use on any of our social media platforms? Are they private? Have they ever been public? And so on. And then I think another relevant consideration is, what is the size of our networks? And how well do we know our friends and followers? And the reason why that's relevant is that even for those of us who've always kept our accounts private, if our networks of followers are really, really huge, I think at least the question becomes, is there anyone potentially lurking in the network who holds very contrary viewpoints and who may be motivated to either dox us or put a spotlight on us and our viewpoints, maybe with the motivation of exposing us to risk of governmental targeting. So I think with respect to social media related exposures, it's really important to ask yourself what platforms have ever been public. Because I think that is relevant to the fact of dragnet surveillance. But I do think that decision making that we can sort of consider as end users is still like an important aspect of potential risk assessment and risk reduction for those of us who are interested in risk reduction. Other online info, it's basically like web-based info or web searchable info, like what is Googleable about us. If you were to search yourself in different ways, what is going to come up in the results that may say something about you and the viewpoints that you hold? That's sort of the analysis for that factor. Moving to the right side of the screen, the next category in the top right is information that we may have provided directly to the government through immigration processes. So this isn't about stuff that's public facing. This is about information that we've given directly to the governmental entities that have power to scrutinize and target us for immigration purposes. So the analysis is what are the contents of any applications that you've submitted to USCIS? If you've been a visa applicant and you've been issued entry permits, what were the contents of those applications? For any of us who have traveled into the US from abroad, what were our encounters like with Customs and Border Protection agents? If we were questioned, what was the nature of that questioning and what was the nature of the answers that we provided? It's not necessarily obvious or I think visible to us. But heightened questioning typically happens in a recorded way, which means that the questions and answers become governmental records. So that's something important to kind of cast your mind on. And then finally, if you've been in an immigration court proceeding, sorry. Oh no. Thanks, guys. If you've been in an immigration court proceeding, what were the contents of, factual testimony that you provided in writing or verbally? Last but not least, on the bottom right, there's a category we've called third-party information. So again, this may not be public facing, but the analysis is what information do third parties have about us and our viewpoints that may be accessible to the federal governmental agencies that are in charge of border enforcement, immigration enforcement, and so on. So we've put at the top of the list hostile third-party individuals or organizations. And I think like we can think about that as doxing entities. What is the information that they have, and it might be public facing, that would sort of mischaracterize us and our viewpoints, and that may be knowable or visible to governmental agencies. Next in the list is campus information and records, employer information and records, um, administrative complaints or legal proceedings that may have asserted anti-Semitism in a workplace or campus environment, or even anti-Palestinian racism in a campus or workplace environment. How could those sorts of complaints and related investigations implicate us and our viewpoints, whether we're the complainant, whether we are the person accused of contributing to a discriminatory environment, or whether we're some sort of a fact witness, what might be known or knowable about our viewpoints that could be lurking in these sorts of records attendant to these kinds of complaints. And then again, criminal records with folks as defendants, folks as relevant witnesses, what could be knowable through databases and information sharing about us and our conduct and our viewpoints. So there's a lot of different things to assess and analyze when you're mapping out kind of the answers to the question of what might the government know about me. So I think there are some special considerations for how to sort of do individualized and personalized weighing of risks that are viewpoint driven. And I think that like one of those is like, what if any personal vulnerabilities does the non-citizen have, like medically, psychosocially, financially? And the reason why that's a relevant thing to think about and assess for yourself is it may mean something for what the experience of immigration enforcement could be like for you that may be different in kind from what it might be like for somebody else who doesn't have those vulnerabilities. So when you're sort of trying to weigh for yourself whether and how to alter something about your decision making, I think this factor gets a place on the scales. Similarly, like if you're someone who's a caregiver of dependents, that's also something that can get a place on the scales for similar reasons, because if immigration enforcement were to materialize against you, it may mean something for the people who rely on you, whether those are children, seniors, people with disabilities, or people with medical vulnerabilities. Weighing their interests and their dependency on you may be among the things that you want to factor in to whether and how to change anything about your behavior for the purpose of risk reduction. And then last but not least, and this is something I flagged earlier, the weighing that we want to invite people to do, it's not only about risk and risk reduction. I think there's a very significant place on the scales for values and sort of prerogatives to remain expressive about viewpoints that matter to us. And that can be because of their importance to us within the context of personal, individual values. It can be because of their importance to us in the context of collective or movement values. But I think that's absolutely something that gets a weight on the scales as well. And so I'd always encourage any of us to allow ourselves to think about that too. So I think I want to sort of zoom out a little bit and kind of put on like a lawyerly hat or a sort of a legal nerd hat, just to sort of uplift a little bit more about the particular role of the Immigration and Nationality Act when it comes to understanding risk, in particular risk of immigration enforcement within the interior or at the border. So there are some removability grounds defined within the INA that have a nexus to speech, sort of on the face of the provisions. One of those provisions is actually a very rarely used kind of arcane provision that got resurrected for the purpose of targeting Mahmoud Khalil and has since been weaponized against other students who've been vocal for Palestinian lives and freedom. We refer to it as the foreign policy ground. In essence, it allows for interior immigration enforcement, meaning detention and removal proceedings, or the border equivalent, meaning exclusion from the US, on the basis of conduct that the Secretary of State certifies frustrates an important or compelling US foreign policy interest. And I think the administration's theory in resurrecting these provisions is that combating anti-Semitism is an important foreign policy objective, and that people who, in the administration's view, based on its definition of anti-Semitism, are frustrating that objective, are vulnerable to being removed, detained, and or excluded on the basis of these provisions. Another sort of speech-related ground in the INA has to do with putative material support for terrorism on the basis of quote unquote communication. And that has potential salience both within the interior in terms of detention and being charged removable, having removal proceedings started against you. It also has salience at the border in terms of being subject to exclusion. So those are the speech-based grounds that can be weaponized against activists or others whose viewpoints the administration is hostile to, with Palestine advocacy at the tip of the spear. However, there are a lot of other removability grounds that the INA defines that on their face have nothing to do with speech, that I think many of the immigration practitioners who might be on this webinar uh, would recognize are like bread and butter or sort of vanilla enforcement tools, but that still lend themselves to potential weaponization against activists with an underlying motive of viewpoint hostility. So I'll give you a few examples of those, although there are probably too many to name at length. But one example is a ground that allows for interior immigration enforcement, or the administration claims that it gives them this authority um, solely based on if a consulate revokes your non-immigrant entry permit. So if you're an F1 student, you've gained entry on your entry permit, you're here in the US on F1 status. If on the back end your consulate revokes your entry permit, the administration has been taking the position that that subjects you to potential immigration consequences, including detention and removal proceedings within the interior. So that has nothing to do with speech, but we've seen it weaponized against student activists. And one example is Momodou Tal, but there are certainly others. Um, Likewise, I think folks have been seeing in the headlines the havoc that the administration has wreaked based on its terminations of international student status in a system called SEVIS, which stands for the Student Exchange Visitor Information System. That's a federal database that campuses have access to for the purpose of stewarding the legal immigration status of F1 students and other international students. And we've seen in recent weeks how in the thousands, the administration has been terminating the legal status of students in that database. And the reason why that's been so alarming in part is that terminations of status that turn on violations of status trigger potential immigration detention and removal consequences on a ground that's just about being in violation of status. So I think, the intention must have been to create widespread fear in the affected target population. And I think with big hats off to advocates around the country under the leadership of really beloved colleagues at the National Immigration Project, there have been lawsuits filed that seem to be getting the administration to sort of at least unwind or undo some of this harm. Although I think a lot of questions remain around if and when the other shoe is going to drop. Will they come forward with a policy to figure out how to do this in a less suspect way? And then there are subsets of students who may still face immigration risk, notwithstanding the restoration of their status. Um, the last thing that I want to uplift here, which I think has been such an aspect of the fear mongering and kind of coercive pressure that the administration has been placing international students and other non-citizens under, is the detention authority that ICE possesses under the Immigration and Nationality Act. So for any and all of the grounds of removal, there's at a minimum discretionary detention authority. And I think we've been seeing in the climate that they have been basically rubber stamping detentions. I don't think that advocates and advocacy networks are aware, literally, of any discretionary releases. Although, as a matter of law, discretion means the discretion not to detain. We've been seeing that discretion has been used pretty much exclusively just to detain. And I think that for folks who don't know well enough, um, uh, immigration detention is notoriously brutal and cruel. It debilitates people, it disables people, it even kills people. And so I think for anyone under threat of targeting that could include immigration detention, you're put in an impossible position. And I think that's very much part of the aims and intents of the administration in subjecting people to risk. So, in terms of how to plan and protect yourself, if you're somebody who decides for yourself in the course of the weighing that we've talked about that you face a high risk of potential targeting, whether on viewpoint grounds or other grounds, I think, for harm reduction purposes or risk reduction purposes, there's at least food for thought in considering whether and how to change your behavior and use with respect to social media. I think those are very personal decisions. And for some of us, the imperative to remain visible and expressive in viewpoints that matter to us may outweigh concerns around risk. For others of us, that may not be so, but it's a pretty personal decision. Separate, I think, from social media use, there's something that I'm going to call device hygiene. Device hygiene has some special relevance to um, uh, immigration enforcement and border enforcement encounters. So I'll unpack a little bit what I mean. If within the interior we come into contact with ICE because they think that we're someone who's subject to detention and immigration removal proceedings, there's at least a question of like, what do we have on our person? What are we carrying on us if and when that risk materializes? And I think for a lot of us, part of the answer is going to be we might be carrying a smartphone. We might also be carrying a laptop. But, what, if anything, does access to those devices potentially mean for increased immigration risk of some kind? And so I think device hygiene has relevance with that kind of scenario in mind. At the border, this has relevance too, but like on steroids, because at the border, the authority to kind of uh, search devices functions differently than within the interior. And I think for at least certain categories of non-citizens, there can be risk in refusing to give access to a device where that refusal could be weighed discretionarily in the decision whether to allow you entry and admission into the United States or not. So the question of like what's on your devices matters for that context too. I think some core like bread and butter guidance that spans these contexts is not to have Face ID or thumbprint ID turned on, to set passcodes that are long and strong, and the longer the better, to have devices powered off with Wi-Fi off, ideally at the point at which these encounters happen. I think that it's worth knowing that in the border context, there is the ability to apply to devices heightened searches that may be able to access content that you wouldn't know to expect could be accessible. Those searches are called forensic searches. They can only be done under circumstances where certain sort of suspicion is triggered. But application of that kind of search can give CBP access to content that's been deleted from a device. So I don't know that that would be intuitively sort of expected, but it's important. It's an important thing to know about the tools and powers that apply to the border context specifically. So device hygiene, meaning like what is on your device? How accessible is your device? How secure is it? These are core aspects of device hygiene. I think within the interior, it's really important to know that absent a judicial warrant authorizing access to a locked device, there's no obligation to voluntarily give access to a locked device. And so to have a device secured with a long and strong passcode is an important sort of right that anyone within the interior has, regardless of immigration status. At the border, the analyses are different and I think can need to be individualized. So it's difficult to kind of give one size fits all guidance. But in the reference materials that will be circulating subsequent to the webinar, there are going to be some really good resources that sort of go into the nitty gritty of some of those considerations. And we'll also uplift how concerned individuals who want personalized free consults can try to access those. Um, so separate from social media usage and device hygiene to reduce risk, number two on the list, I think has relevance for anyone who concludes for themselves that they're at very high risk or high enough to want to consider contingency planning and preparation for the possibility that risk could materialize into actual enforcement. So for some people, that may feel empowering as a way of regaining control or agency over a kind of scenario that otherwise could stand to feel quite out of control for understandable reasons. So when we talk about anticipatory emergency planning, we're talking about things like anticipatory legal rapid response. So we can bottom line maybe what we mean by that. In part, for some people, that can mean like an individualized emergency sort of back pocket lawsuit that someone on standby could have ready to file the moment that there's constructive knowledge that immigration enforcement or border enforcement risk has in fact materialized. I think that for that kind of strategy, uh, planning in advance is sort of ideal. So the sooner that light bulb turns on, the more tenable it is to try to identify resources that may be able to support you for that kind of strategy. Likewise, I think another aspect of anticipatory emergency planning that can be very, very difficult to broach at a personal level or to counsel someone else about is family planning or planning for people who are your dependents. So I think the question becomes like, if you are forcibly separated from people who depend on you, what can be kind of agreed upon and kind of thought through now about how their needs are going to be met in the event of that kind of forced separation? So it's a very devastating thing to, I think, try to engage with. But I think for at least some people who are caregivers to dependents, it can be empowering or reassuring to go through the difficulty of that kind of exercise and that kind of forethought, because it can provide some sense of security that if the worst case scenario materializes, that there's a contingency plan in place to make sure that the needs of loved ones are met. So again, in our reference materials, there are going to be some resources that I think will point to how any of us can learn about how to do that kind of family-oriented contingency planning, which typically is driven by state law frameworks. So, sorry. Finally, I think another aspect of planning that's super important is, knowing your rights if and when you're having an encounter with ICE or with CBP that relates to enforcement against you of some kind. So I think that in a subsequent webinar that the Rutgers folks are going to be hosting, there's going to be a lot of in-depth content about the rights that non-citizens should be aware of. I'm going to uplift some of those core rights and kind of delineate them in the context of the border and within the interior. I think within the interior, here are some sort of golden rules. Within the interior, one golden rule is, are you free to leave? So anytime you're in contact with an individual or a group that claims to be part of a law enforcement arm, whether it's local police, whether it's federal FBI, whether it's ICE, a core question to ask at the outset is, am I free to leave? Because if the answer is yes, you are not in custody, there's no obligation for you to stick around, and you can walk away. If the answer is no, then that signals to you that you're in custody. And then I think the sort of analysis becomes, how do you keep yourself safe? How do you reduce risk to yourself now that you're in custody? So am I free to leave? Golden rule number one. I think golden rule number two, there's different things to say here, but I think knowing that you have a right not to incriminate yourself, knowing that you have a right to remain silent is pretty important, no matter which law enforcement agency you may be in the custody of. And it may not always be clear. You can ask law enforcement agents to identify themselves, but it's not always the case that they have to answer truthfully. And I think in the case of ICE, there's a lot of data to suggest that they can and do lie, at least in terms of how they announce themselves. But standing on your right to remain silent, I think, is a potentially very protective thing to do to avoid self-incrimination across different legal frameworks. I think for folks who have an attorney, saying that you have an attorney, saying that you want to call your attorney can be protective. And I think for folks who have language access needs, or vulnerabilities with respect to medical conditions or disabilities, I think announcing these things can be protective in the moment. So if you don't speak English, if there's a way that you can announce that, that may be protective of you. Likewise, if you have a medical vulnerability or a disability and it feels safe to you to announce that, there's at least the possibility that that can be protective of you. I think in the reference materials we're circulating, there's going to be a lot of really good content that digs into the nitty-gritty of rights awareness, both within the interior and at the border. So we'll encourage you all to kind of avail yourselves of that. And there's also a lot of additional complementary content about how to document law enforcement encounters, including ICE encounters. That can be, I think, powerful for advocacy purposes. Sometimes it can be risk reductive in the moment. And there's a lot of other content too that I hope will offer some food for thought. But I think with that said, I'm at the hour mark. I'm going to just offer a couple of kind of closing remarks that are maybe a little bit more hopeful. So I want to uplift to everyone that for the past year at least, Muslim Advocates has been working really closely with partner organizations, including the CLEAR Project, the Arab Resource and Organizing Center, CARE New York, the National Immigration Project, Project ANAR, the American Arab Anti-Discrimination Committee, as well as some really stellar individual attorneys who have a lot of immigration practice experience, including and especially with students. So those attorneys include folks like Ben Alwardi and Massa Khambabai. We've been working really closely with each other for the purpose of support and defense of international students and non-citizens more broadly who are worried about viewpoint-based targeting. We've set up sort of a front door shared email address that is like a intake stream for people who are wanting individualized consults to understand sort of what the threat landscape means for them. We sort of match those intakes to our pool and a vetted pool of volunteer attorneys that is growing a lot. And I think, you know, this is one resource that we want to kind of name to folks in this space that exists. It's a good fit for individualized consults. It's a good fit for potential KYR engagements. It's not going to be a good fit necessarily for anticipatory legal defense or rapid response needs to sort of like pre-prepare emergency lawsuits. But I think for folks who decide for themselves that they have that kind of need, at a minimum, what we have been trying to do is bridge folks to trusted resources that may be able to offer resources on that front. So just bear in mind that there are free resources out there subject to resource constraints, but that can meet at least some needs at a minimum to help people get oriented to what the landscape means for them. And then finally, I think it's important to conclude with acknowledgement of what are some ways to plug in and resist, no matter what our immigration status is. And so I think in this context, what I want to really uplift is the role that campuses can play either to reduce harm to non-citizens and international students in particular, or to capitulate to and kind of facilitate harm. So advocacy that's campus directed, I think, is a potential opportunity in the climate. Campuses are under a lot of pressure to capitulate, make no mistake about it. There are hostile committees of Congress that are leaning on campuses to disclose student records. There are funding threats to campuses to lose federal funding if they don't capitulate in one way or another. But I think that this is all the more reason why it's important to remind campuses through advocacy about the obligations that they owe to their constituencies, including international students, especially because of how campuses hold themselves out in terms of their missions, which, you know, they claim to be to promote learning, to promote sort of robust exchanges of contrary viewpoints on matters of public concern and political concern. And so, you know, either campuses are about that or they're not about that. And I think they're claiming to still be about that. And I think this is an opportunity to try to hold them accountable to that and remind them how they may expose themselves potentially to liability when they turn their backs on that. So just wanting to kind of flag that there are creative opportunities to advocate through campuses in this climate, where those of us with relative privilege may be able to kind of be out front for those fights. And there are also resources in the reference document that's going to be circulated to you that will offer some food for thought about content for this kind of advocacy. But that brings me to the end of my presentation. Thanks so much for bearing with me.
Are there services like Reputation Defenders, an online reputation management service, that are helpful for diminishing the risks that searching for a person's name will lead to defamatory results, like a Canary Mission profile? Or are there any nonprofit groups that can help students and others of limited means pay for such services? And before you answer, I just want to give our audience a little context. At least since October 2023, and arguably, many years before that, there are numerous blacklists, and they're very McCarthyistic in nature and authoritarian in nature, that are created by private groups that self-identify as pro-Israeli and Zionist. We have Canary Mission, we have Betar. Those two are actually based in Israel, but we also have other lists in the US, and those blacklists have increased exponentially since October 2023. And many of the people listed on those lists are disproportionately Palestinians, Muslims, Arabs, and South Asians, and Black and brown people. So there is a very racist component to it. Since October 2023, we're seeing an uptick in Jewish individuals, especially anti-Zionist Jewish individuals, also on those blacklists. And the objective is clear: to smear, to intimidate, to harass, and to threaten the safety of those people, and to threaten their employment as well. And so these are very hostile, malicious efforts. And what we've seen since the election of Donald Trump in January 2025 is that these blacklists and these hate groups are sending their blacklists to the Trump administration and demanding that the state abuse its power, abuse its authority under law, under the color of law, to do its politicized and racist work, right, of these pro-Israeli Zionist groups. So I think it's really important to name the threat and to name the victims and the targets. So that being said, have you heard of apps such as Reputation Defenders or any others that you can recommend? And also, are there any sources of funding for students in particular who may be on these authoritarian blacklists, and they can find a way to protect themselves, their safety, and their reputation and their employment?
Yeah, so I think the short answers here are that yes, there are resources out there, some of which are paid services that effectively can help kind of push down the findability online of uh, online doxing content. I think there are a number of examples. I don't sort of have a read on their relative strengths or weaknesses, but in the reference document that we're going to be circulating, one sort of um, NGO partner that has expertise on these issues, whose resources are referenced, is Equality Labs. So there's a lot of good content that they steward and warehouse that is specifically pertinent to this issue of like anti-doxing measures. As for anyone who has been doxed, what are the things that you can do or consider to kind of risk reduce or harm reduce because of the risk you'd otherwise face for as long as the doxing is highly searchable or highly search accessible. I think that some of the search engines like Google may offer free sorts of processes that can be considered, that if they result in a kind of outcome that's desired, may have the same sort of consequence that use of a third-party vendor for a cost could have. I would say for folks interested in using search engines' own features to this effect, it could be worthwhile to get sort of some individualized advice about risks and benefits before you do that. But I think in the reference document that we're circulating, the materials of Equality Labs are flagged. And I think that we'd be happy to kind of prepare maybe sort of a spread of some of the most sort of recommended or used third-party vendors too. On the question of cost, Professor Aziz, I'm not familiar with sort of like funds available to cover these costs in particular, but what I would say is this, for international students who have been doxxed and want to consider a paid third-party service to try to reduce related harm. If you've got a good relationship with folks on your campus, especially if you've got faculty advisors who are on your side, I don't know that there's much risk in using those relationships to explore if the campus may have funds that could help with this sort of need, especially if there's any campus-based nexus to the doxing. Maybe that's something that could be considered. But yeah.
Thank you for that. And we will also put those resources on the website of CSRR. It will be under csrr.rutgers.edu. Press the resources button and go down to Know Your Rights. And we will place those resources there, as well as this. Multiple people are interested in knowing more about digital security at the border and the rights they have, as well as the strategies they should use to protect their privacy and their safety. So first is, can CBP, Customs and Border Patrol, force a person to unlock their phone at the border? Second, can forensic searches access deleted messages on apps such as Signal or WhatsApp? And then finally, should people who are concerned with their privacy, or, and then by extent, their safety when crossing borders, should they use a travel phone or burner phone when crossing the border? And is that a form of best practices for device hygiene?
Yeah, I think so. Where I'm going to start in terms of, can you be forced to give access to a locked device that's with you when you're coming in contact with Customs and Border Protection? The answer to that question, I think, has very much to do with citizenship status and immigration status. So I said earlier that no US citizen can be denied entry into the US as a matter of law, period. And that includes a US citizen who refuses to give access to a locked device, um, absent sort of a judicial warrant. So that doesn't mean that you can't still be subjected to unwanted consequences as a US citizen at the border if you refuse access to your device. It means that you can be detained, you can be questioned, your device can be seized and taken from you. But ultimately, you can't be denied entry. And I think the knowledge of that kind of ironclad right, that you have a right to re-enter, can be, I think, solid ground on which to stand for citizens who are comfortable standing on that right, to know that, like, the sort of worst that can happen is seizure of the device, some period of detention, some questioning, but ultimately they have to be let inside. In contrast, though, if you're a lawful permanent resident, especially like, I think for lawful permanent residents, here's what I'll say. Lawful permanent residents that have ties to the US, who are like returning to the US after time spent within the interior, um, they have, I think, rights at the border that are important to know about too. In essence, they are not supposed to be subject to summary exclusion or processless exclusion from the border. Worst case scenario, if their inspection by Customs and Border Protection sort of goes off track, they could be asked to voluntarily abandon their residency status and then sort of leave, or they could be processed into the interior for immigration detention and removal proceedings. I don't say that lightly to say like that's like the worst case scenario and that's not so bad. I just say that unlike other categories of non-citizens that I'll turn to next, you're not supposed to be subject to processless summary exclusion from the border per se. And so you have a right to sort of challenge your admissibility through procedures that unfold in immigration proceedings within the interior, and that may come with the price tag of immigration detention. So I think for lawful permanent residents, like it's going to be a very personalized decision how you view what it means to be under scrutiny by CBP at the point at which you're reentering. For some lawful permanent residents, the judgment might be, you know what? I have the right not to be summarily excluded. I'm going to stand on my ability to refuse access to my device. And if that has an unwanted consequence for me, maybe I'm willing to assume the costs of that um, for the purpose of not capitulating. For other lawful permanent residents, the calculus may be different. So I think this is a context in which personal facts and circumstances and sort of decision making in the moment is maybe different for different people. For people who are in non-immigrant status, so international students, people on work visas, anyone else whose a permission to enter the US is for a temporary purpose, you're the most vulnerable at the border because if your inspection goes kind of sideways and you're not found to be someone subject to admission and entry, you can be subject to summary removal from the border, issued an expedited removal in a processless way. And then that has the consequence of prohibiting your entry for a 5-year period. So if you're in that category and you're dealing with Customs and Border Protection, you're the most vulnerable to sort of the way that Customs and Border Protection exercises its discretion. And so if they say to you, I know your device is locked, I want you to unlock it for me, you have to weigh for yourself kind of pros and cons, risks and benefits of how you decide to answer, depending on your sort of risk tolerance or risk aversion, and you know what it is you're willing to uh, uh, assume in terms of risk and what it is that you wouldn't want to assume and that you'd want to avoid. And it's a very personal decision that there's no one size fits all answer to. But this just really speaks to how extreme the authorities asserted by border protection are in the border context and how differently situated different people are by virtue of citizenship status and immigration status in terms of what it means for them to come into contact with that power. I think I've forgotten the other questions. Sorry. I'm
No,
sorry.
no, that's all very helpful, and we're actually running out of time.
Okay.
So I want to thank you so much
Sure.
for this informative presentation, which is just the tip of the iceberg. There's so much more out there to learn. And as we stated during the presentation, there will be a resource guide that we will distribute to attendees. And for those who don't receive it, you can go to csrr.rutgers.edu, go to the resources tab and press the Know Your Rights tab, and that guide will be there. And before I formally end, I just want to put a plug in for my book, The Racial Muslim, When Racism Questions Religious Freedom, which helps to explain why Muslims are so targeted, and Palestinians who are often presumed to all be Muslim, when in fact it's only about 80% that are Muslim and 20% that are Christian. But I think it's really important for all of us to understand what is the legal, political, and social backdrop that makes it so easy to scapegoat Muslims and to scapegoat Palestinians in order to erode civil rights and civil liberties for them. But then that becomes the norm, whether it's the way that laws and policies are enforced or that laws and policies actually change, which we saw with the Patriot Act and other legal changes after 9/11. And so we do have shared destinies, we have shared futures, and we live in the same society. And I think that's really important for everyone to appreciate that even if you may not directly be impacted right now, or your friends or your family, because you are not Palestinian, you're not Muslim, you're not South Asian, you're not an immigrant, you're not an international student. The reality is that the people in power right now who have clearly stated their authoritarian tendencies and desire for a quasi-totalitarian, if not outright totalitarian state, that they are seeking to change, make significant structural changes to our legal regime, especially vis-a-vis individual rights and free speech and academic freedom and political rights. And the universities and the international students at the universities and the immigrant students at the universities are the canary in the coal mine. And they're figuratively dying, right, from the toxic air in the mine. And that toxic air is effectively the authoritarian practices and the changes in the way that the government is enforcing, or more accurately abusing, its power. So it's essential that all of us lean in and protect the rights of the most vulnerable, and also just protect our society from its tendency towards authoritarianism, which we've been seeing. Some of us think since 9/11, others think since 2017, and others who may be the most optimistic think since 2025. But that's more of an interpretation of history. And so with that, I will just remind everyone, please register for the next Know Your Rights presentation, which is directly focused on immigrants and international students. It will be featuring Professor Raquel Aldana, who is an immigration law scholar and immigration law expert. You can do that by going to go.rutgers.edu/CSRR Know Your Rights, or go to csrr.rutgers.edu, press the events tab, and go to upcoming events. If you've missed any of our past events, everything is recorded and put on the YouTube channel of the Center for Security, Race, and Rights. So please subscribe and watch at your leisure. We have over 110 academic lectures, teach-ins on Palestine, Know Your Rights workshops, and also subscribe to the Race and Rights podcast, which I host and features numerous international and nationally known experts on areas that impact the civil and human rights of Muslims, Arabs, and South Asians here in the US as well as abroad. And so with that, thank you so much, Golnaz Fakhimi, for your generosity of time and expertise in educating our diverse constituency.
Thank you so much, Professor Aziz. Thank you so much, everyone. Take care.
Okay, مع السلامة.